So that's wonderful. So welcome everyone to the top 10 wage and hour law violations and how to avoid them with attorney Jim Reidy. Unfortunately, you're going to see Jim's face as a photo and not his actual video face because I made some sort of bauble when I made this Zoom link. And unfortunately, he doesn't have video approval. So unfortunately, you'll just see his photo. So I'm sorry about that. So he's going to take us through some slides. He's also open to any questions that you might have throughout. You can just raise your hand or throw a question into the chat. I can, if he doesn't see it, I can flag it and ask the question for you. So Jim, I'll hand it over to you and let you get started.
Great. Thanks, Amy. You know, it's been said for years I have a face for radio, so apparently this really confirms that. So, you know, and I went to such trouble today to brush my teeth and comb my hair, such as it is. So, well, welcome everyone and Happy New Year. You know, this presentation is something I do every year, a top 10 list of wage and hour violations in New Hampshire and how to avoid them. And the purpose of this is to educate and you know, basically avoid the shoals that you might see in steering through these sort of turbulent waters in this economy, especially. This top 10 list, you'll see that there are some returning favorites every year and then some new ones. And also the jockeying different positions for the violations each year. But let's get started. And I was saying to Amy that this is pretty informal. I'm a member of New Hampshire Lodging and Restaurant Association. And I actively represent a lot of your members, and I'm a frequent flyer at the Department of Labor. I've been doing labor and employment law for over 33 years. All I do is represent management, and very few issues these days sort of surprise us. They're always challenging, but I think that the margins are so tight in your business as we're coming into hopefully a post-pandemic era that it's important to, you know, be aware of these issues and avoid the problems because the problems can be expensive. So it is our top 10 wage and hour violations. This is, while I can talk to you about federal issues, let's focus on state issues under state law, RSA 275, RSA 281A, and RSA 279, which is the wage and hour statute, the workers' comp statute, and the minimum wage statute, which deals with youth employment as well. So every year we review the enforcement activity from our friends at the Department of Labor, which is both involves their wage hearings and also their inspections and the penalty assessments that arise out of those inspections principally. And we'll talk about the potential pitfalls for noncompliance with those state laws and how to avoid what we refer to as the Department of Labor's annual naughty list. It was another busy year for our friends at the Department of Labor. The inspectors are out there and they are visiting employers now with greater frequency. Now, what's interesting about that is that but first let's talk about, about the wage claims. Wage claims are when an individual files a claim against their employer and they basically say, wages were not paid to me that were due. In fiscal 22, which was July of 21 to June of 22, there were over 500 wage claims filed in New Hampshire by individuals, again, against their employers. Every time you file a wage claim, as an individual files a wage claim, the employer files a response. And for those that have been through this, the employer files a response. By filing the response, the Department of Labor does not dismiss the claim. It says, if you've objected to the claim, now we're going to have a hearing. And the hearings are held before the Department of Labor hearings officer, one hearings officer, and it's a tape recorded session. And during COVID, those were virtual. More and more, those are going back to being in person or have the option for virtual. It's an exchange of information. The employee outlines what he or she believes are due by way of wages. The employer presents its side and presents either testimony or documentary evidence or both. And then as a result, the hearings officer makes a decision. Those decisions are whether or not wages are due. And if the hearings officer finds that the employer willfully refused to pay wages, then the damages could be up to double the amount of the wage claim. So that's when an individual files a claim against the employer. And if you've ever been through that process, it depends upon the hearings officer, it depends upon the evidence. Typically, the individual may or may not be represented. Employers are typically represented in those because the stakes are higher. It's a roll of the dice for the individual, for the employer, likewise. But in those cases, it's probably not a bad idea to have counsel with you, or at least counsel prepare you in advance of the hearing, depending upon the amount at issue. Now let's switch to inspections and civil penalties. The inspectors from the New Hampshire Department of Labor conducted over 200 on-site inspections in fiscal 22. Now that was down significantly from the 800 plus inspections that were conducted during fiscal 21. That's because those inspections largely were done via email, mail, and telephone conference in fiscal 21. Fiscal 22, they were back in person largely and getting back up to speed again. But as a result of those audits, the Hampshire Department of Labor, even though they were down considerably, proposed some pretty hefty civil penalties by violation, by type, and by frequency. What does that mean? That means typically they look at how many times there was a supposed violation, how many employees were involved, and the type of the violation. And based upon that, they can hit you with civil penalties per employee, per day, per violation, starting at about $100 and going as high as $1,500 per day, per employee, per violation. So in other words, that math gets expensive. Those can have a substantial impact, certainly on your bottom line. Again, your margins are thin. You've got lots of other challenges with staffing and other issues. So thankfully, over the years, the Department of Labor has allowed what is called an informal conference. So the inspector comes out, you provide all the information. And by the way, for those that have not had an inspection before, you can contact me, and my contact information is at the end. And for free, no fee, I will send you a copy of an outline that we've done, which is how to prepare for and deal with a New Hampshire Department of Labor audit. You also have one for U.S. Department of Labor. The benefit of that is it provides you with a guide to dealing with the inspector. And basically it's be nice, be civil, be respectful, and be cooperative. Don't be a doormat, but be cooperative. Because the way in which you conduct yourself with the inspector actually has a way of, they're human beings, influencing what violations they find and how much they're going to dig in their heels with regard to violations. And later, so once they have the inspection, they prepare an inspection report, they present it to the employer to sign. The employer can sign, not acknowledging that the information found is accurate, but simply acknowledging receipt. And that's what I recommend you write on that. I acknowledge receipt of this on this date. Then you get another letter from the Department of Labor when they propose civil penalties, and sometimes that is sticker shock. You get the letter and it says, we found these violations and it turns out to be this amount. With that, you can either pay that amount or you can request what is called an informal conference. You have two options. You can do an informal conference or you can do a formal hearing. The problem with a formal hearing, which I'll talk about in a second, is if it's wage adjustments, which are you must pay this list of employee these wages, it's a separate hearing. It's a hearing before a hearings officer, and the civil penalties go to what's called the Civil Penalties Appeal Board. You can do both by going to what's called an informal conference, which is you sit with the wage and hour administrator from the Department of Labor and the inspector, and you talk about compliance, you talk about arithmetic errors they may have made, and you talk about ways in which you're going to go forward. And hopefully with that, they'll reduce the civil penalties. In fiscal 22, they reduced the original civil assessments, and the Department of Labor used to keep that number, but they don't anymore. And all they do is they keep what the actual assessments were, and what they actually collected after those inspections and civil penalties from this last year, which was again up till July of 2022, was $275,000. Now that's a significant increase from what they collected in fiscal 21, but that's still a substantial amount. If your workplace was hit with even a fraction of that when you weren't counting on that in your budget, that could be significant. The bigger issue, though, is an issue with regard to, just have a quick question here. Okay, I've got some questions there. Amy, did you have something?
Oh, I just wanted to make a call out. There was a question in the Q&A and in regards to an hourly employee being on call.
Okay, I'll get to that. Sure, great.
Yeah.
I'll put that aside for a second, but I will get to that.
Perfect, thank
And
you.
by the way, I have no problem at all asking questions. I'll go through this and I'll talk about on-call and related issues. Anything you want to talk about with regard to wage and hour, I'm happy to do that. So the wage adjustments paid during the same period, that's the bigger issue. Again, that's where the Department of Labor gives you a list of employees and they say, you owe these employees this amount. That totaled last year, fiscal 22, $1.2 million. So on top of the over $200,000 in civil penalties, you're looking at 1.5 million dollars doled out by employers last year, and that was significant. That was a significant increase. So what the Department of Labor did in this last year was fewer civil penalties against the employer, but said effectively, we're going to be Robin Hood and we're going to require that you pay these employees this amount. Now, that's for a wide variety of reasons. But when you get that and you go to an informal conference, rarely does the department reduce that amount. What they'll say is instead was, if you pay these wage adjustments, then we can talk about reducing your civil penalties. Well, that's a lot. So if you decide not to go that route, you have to go the way of a wage and hour hearing at the Department of Labor to reduce the wage adjustments. But say you've got 30 employees and they get an assessment for all 30, you're going to have got to do a substantial hearing process to go through to reduce those. So the better course of action would be to be in compliance, of course, in advance and try to resolve these things at the inspection stage if there are problems, because once they've written the report, it's hard to get the department to back down. I think I've moved there we go. 1.5 million was an amazing amount. And that is one where I will say, coming out of the pandemic, I was surprised to see. But the activity we're seeing from the Department of Labor, both US and New Hampshire Department of Labor, looks like they are ramping up. And it looks like they did give grace during the last 2 years of COVID, but now it looks like they're back out there and saying that we're going to look for violations and wages due to employees. So again, the stakes are high, and to avoid violations and that expensive either civil penalties or wage adjustments, we recommend focusing on these and other compliance tips to avoid the problems that other employers experience this year. So the top 10 list. Number 10 on the list, and so it's in reverse order. And when we say top 10, we mean the most common. Misclassifying of employees as, individuals as employees. I'm sorry, strike that. Misclassifying individuals as independent contractors when they were actually employees. And there's a test, and the test that they use here is RSA 281A2, which is the workers' comp statute. Under RSA 275-42, which is the wage and hour statute, there is a similar test, and basically comes down to what's called direction and control. Does the individual do what you do? Do they do it at your workplace? Do they do it at your direction, meaning you control the manner and method and timing of what they do? And do others who are employees to perform the similar task, but the contractor is doing the same task effectively? Remember Bill Gates and years ago with Microsoft, they had individuals sitting in one cubicle were employees, and the next cubicle were deemed to be independent contractors, and they didn't get stock options. And they said they're doing the same thing. So you have to be very careful, because with low labor participation rates, with low unemployment and difficulty filling positions, a lot of employers, not necessarily in hospitality, but possibly, used independent contractors to perform certain tasks and services. If they don't meet the test of being classified as an independent contractor, they are by default determined to be an employee. And therefore, in this case, they should have received workers' compensation coverage. They should also receive regular wages as opposed to being paid on a 1099 or W-9 basis. So just be careful. I'm not thinking this is as big of an issue for you folks, but understand two things. One is there's independent contractor tests for wage and hour, for unemployment, for workers' comp. There is also an independent contractor test for the IRS, and the US Department of Labor came out with a rulemaking for yet another one where they flipped from the Trump administration back to what was under the Obama and the Bush administration, which was more of a strict standard, which is you are deemed to be an employee unless you meet the test of being an independent contractor. So be very careful in that regard. And a couple of things. If an individual says, but I want to be an independent contractor, I effectively want to work under the table, or I want to work on my own, and I've got my own business. What they want doesn't really matter. What matters is, do they satisfy the testing? Could you have an agreement with them that follows the test? And if any of you want a copy of a standard independent contractor outline, I can provide that as well. But again, what the individual wants doesn't matter. What matters is, do they fit within the test of being an employee or an independent contractor? So the stakes are high in this regard, because if you have someone who's classified as a non-employee or independent contractor and they're injured, they're not covered under your workers' comp policy. And if they're not covered under your policy, you may have a substantial unfunded liability for lost wages, but also for their medical bills. They're not covered under your health insurance plan. They're not covered under your workers' comp plan, and that could be extremely expensive. So be careful in that regard. Number 9, failure to have a written safety plan, a joint loss management committee, or a safety summary form. Now, back in the day, not too long ago, that was for as few as 5 employees or as few as 10 employees to have a plan in place that you updated every 2 years, a joint loss safety committee that met quarterly. You post the meeting notice and so on. A couple of years ago, they increased that to 15 employees for both a safety summary committee and for a joint loss management committee, and the safety summary form that's submitted to both the plan and updates to the plan submitted to the Department of Labor. I think this was a COVID-related issue where employers simply focused on other things, keeping the doors open, the lights on, and services. So, and then the other question often came up with, if I have an employee who had COVID, do I list that as potentially a workplace hazard? Because that's what this is. It's listing known hazards or accidents and what you've done to correct those in the workplace. It's similar to the OSHA 300 report, but it's one that's filed with the state, and you have to have the records. And it's a safety committee comprised of equal parts of management and rank and file employees, meeting at least quarterly, and you post the minutes from those. That's often overlooked by employers of all types and sizes. Again, you have to have more than 15 employees, but that's not a bad idea to have that. And in hospitality and restaurants, especially like in a kitchen issue, you want to make sure you've got any known accidents. Again, it's a workers' comp report, first report of injury, but also your safety report and what you've done to correct the problem. And that's effectively it. And you see there that you have to have those regular meetings quarterly and maintain the minutes from those, and they're posted and filed as you update your plan filed with the state, which you can file electronically and have been for the last couple of years. Now we're getting into the wage and hour issues, paying later than the designated pay day. And this one shows up on the list almost every year. And that's employers need to be sure that the deductions from wages align with the outlined state, those outlined in the state statute. It also is, so it's failure to pay wages on time, but it's also a failure to pay the full amount due. Those are the issues, RSA 275-43 and also LAB 803-01, which is a regulation. So let's talk about those in 2 parts. The first, failure to pay wages on time. So what are we talking about there? So under New Hampshire law, you can either have a weekly pay period or a biweekly pay period. You can have a monthly pay period if it's approved by the Department of Labor. But let's focus on the 2 that you can have by default, weekly or biweekly. In that case, you must pay employees within 8 days from the end of the pay period that they perform the services. 8 days from the end of the pay period. So in that regard, what happens if, say, your pay period closes on a Saturday and you want to get your payroll together on a Tuesday so the employees can be paid on Thursday? And on Tuesday night, after everything is into the payroll service, an employee says, oh, by the way, I had some extra time. I didn't fill out my timesheet, or I forgot to close out this or that on my time card and so on. So I've got some extra time. And if the employer says, well, you'll just have to wait till the next pay period because payroll closed, Department of Labor takes a position and says, no, you've got to cut a manual check for that extra time. And that one we've seen over the years. And it doesn't matter how little it is, cutting a manual check is what their position is. Can you discipline the employee for not getting their time in on time and the cost associated with cutting a manual check? Well, you cannot assess the cost for cutting the manual check, but you could say, look, this happens all the time. You've got to get your time in on time, but be careful about disciplining employees because it may be a problem with your system as far as entering the time. But again, in this day and age, we want to retain as many employees as possible. I would just continue to remind that I have supervisors monitor to make sure all the time necessary, which we're going to talk about in a minute, is in. And then the second one is failure to pay the full amount due because of unauthorized deductions. Under our statute, there are specific things that you can deduct for, and there are things you cannot deduct for. And it's a list of 12 with many subparts. So legitimate loans to employees, tuition, accidental overpayment, if an employee wants to make charitable deductions, and the list goes on and on. You have to fit specifically within it. Now, there is one catch-all, and the catch-all is, I think, the 12th item that they said, basically, what employer and employee can agree upon, you can withhold from wages, as long as it's for the benefit of the employee, not the employer. And again, these things have to be reduced to writing in advance of the actual deduction from wages. So that's the requirements, but make sure you fit within that you pay on time, that if there's extra time that didn't fit into the payroll, you have to cut a manual check. And then with regard to deductions, you have to follow the specific deductions that are outlined in the statute. Number 7 is working without parental permission. And we're talking about those from 15 to 17 effectively in the rules in that regard. And they're very, very specific. And this is one the Department of Labor does not budge on. And what we found in the last year was a lot of employers were hiring younger workers under age 18 because they needed to fill slots. And some slots that, again, some positions you cannot have a younger worker working in under both federal youth laws and under state youth laws because they may be deemed to be hazardous. But there are also other restrictions on the days of work, the hours of work, and whether it's during a school season or not, and also whether it's the kid's homeschooled or attends in person at the school, doesn't matter. You go by the school calendar. But if it's the worker's under 16, you have to employ the youth certificate working papers within 3 days of his or her first day of employment. My recommendation is have that stuff in place before the kid starts work. If the worker is 16 or 17, the employer has to obtain permission from the parent or guardian before the person can commence work. Again, the most important thing is for the younger workers, it's the school certificate and the parental permission. Older workers, meaning older on 16, 17, you have to have the permission in place. Be very, very careful in this regard. My recommendation is with regard to youth workers, one, having the paperwork in place, making sure it's absolutely correct, that you keep a copy in the file for that individual. And then further, that they have different colored name tags or something to indicate that there's a restriction on their hours of work and their days of work. And I'm talking about if they work 5 or 10 minutes longer than they were supposed to, that's a violation. So you should have a governor in place where, like, you have your meeting reminder in Microsoft that says 15 minutes in advance of a deadline, something pops up. Similarly, you should have that. So the supervisors or managers know that kid has to clock out for whatever reason before the limit on time. And these are expensive. And this is where the Department of Labor rarely will negotiate and give you a lesser amount for those violations. So be careful in that regard. Failure to pay, number 6 is failure to pay all wages due for hours worked, including short breaks, overtime, shift differentials, and fringe benefits due. That's a timekeeping issue. and we've got 2 timekeeping violations on this list, but it's short breaks, meal breaks, reporting time. Failure to comply with those things results in employees not being paid all the wages due for hours worked. So what does that mean? You can't properly pay an individual unless the time is recorded. So what does that require? Well, does an employee have to use your time clock to punch in and punch out? So let's talk about what that means. The state law says that the employer shall keep an accurate record of all hours worked for employees from the beginning of the workday to the end of the workday, whenever that is. Now, COVID complicated that a little bit with people working remotely, and probably the vast majority of your workers did not work remotely. But for remote workers, they would have to have the same obligation of clocking in and clocking out, beginning of the workday, end of the workday, and any bona fide break in between, meaning a meal break or a short break greater than 20 minutes in duration. A short break that is less than 20 minutes in duration. And think about in a restaurant where you have someone who's serving as a hostess, and then is going to be a server or something else. They're 2 different jobs within the same day, cobbling together a full workday. If that break between jobs is less than 20 minutes, the Department of Labor calls that continuous hours work. But not to overly complicate that. So it's beginning of the day, end of the day, with any bona fide work break greater than 20 minutes in duration. And that's how you record the time. Who records the time? Well, the employer does not record the time, meaning you don't pay based on a schedule. You pay based on the actual time records. The employee keeps the time record. Now, whether that's a automated system where they badge in, or they have a punch card, or they log on, or they fill out a piece of paper, or they write on the back of a napkin, whatever the system is, or even if you have a system, an HRIS system, you have to make sure that if someone has an additional record, meaning, yes, the Department of Labor, US Department of Labor actually sent out an app a few years ago, which allowed employees to track their time separately. What if an employee tracks his or her time on the back of an envelope or on a napkin, or they send you an email saying, I worked extra time? You have to include that extra time, believe it or not, even though they didn't use your regular timekeeping system. So that's something to keep in mind. You don't want to tell employees that. You want to say, use our system. But if someone submits something else in addition to your system, you have to accept that. So again, it's beginning of the workday, end of the. When does the workday begin? It's when they commence work for the benefit of the employer. So what if you have a situation where somebody comes in and their shift is supposed to say start at noontime, and they show up at 11? Okay, they're supposed to start at noontime. So that's when their workday, that's when you counted on them having compensable time. But they're walking around and say, hey, let me help. Let me go take silverware and wrap it up in napkins, or let me, bust these tables, or let me sweep out this area. I'll take the trash out for you. Once they start work on your behalf, they've clocked in. And you say, well, they volunteered. They volunteered, but it's compensable activity. So be careful in that regard. What if somebody comes in and they have to come in and put on, let's say your kitchen, they have to put on a uniform. That's called donning, where they're actually putting on specific protective gear, clothing, hairnet, uniform, apron, booties, whatever it is. And the same is true with your cleaning crew. That is counted, generally speaking, it's called donning. And when they take it off at the end of the shift, that's called doffing. That's counted as hours worked as well. The same is true with preparation. Say in a kitchen sitting, if they come in and they have to set up the kitchen a certain way, that's commencing work on, even though they haven't started using the kitchen yet, if they're setting up the kitchen, and so on, whatever their activity is. If they're working in your bookkeeping in your office and they come in to set up things and once they log on, even though they might go get a cup of coffee or do something else, the workday starts. So we're talking about hourly employees largely, but we're also talking about salaried employees who are not deemed to be overtime exempt. And I can answer questions in that regard, because if someone has a question about it, it isn't just if you're salaried, you're overtime exempt. You have to be salaried and fit within the statutory exemptions for being executive, administrative, computer professional, or other professionals. You have to fit within that. That's a separate topic, but timekeeping, really important. And then remember, you have to then, with that time record, you have to put that into the payroll system. It's a continuum. The employee takes the record, you put it into the system, the employee's paid that amount. Now, what if a person forgets to clock out or clock in? Can you modify their time record? The short answer is yes, you can. However, you have to notify the employee that you modified their time record, and the employee must initial the change. Does the initial have to be written on something? It should be. The Department of Labor hasn't really caught up with that, but can you have some sort of electronic record where the employee initials? Yes, but preferably it's person initials their change, put their initials. In mine would be JPR, and on this date, I acknowledge that you changed my record. That has to be done as well because the Department of Labor looks at that. Accurate record of all hours worked. Amy, you had another question.
I just noticed that the Q&As are piling up and a couple of them might be part of this topic. So I just wanted to draw your attention to them in case it made sense to answer
Great.
them.
Let's take a sidestep and take a look at those.
Yeah.
So on call, I'll talk about that one right now. With regard to our employee being on call, our employer is required to pay for this time if the employee does not actually end up being called to work. Guess what? The answer to that is, it depends. I learned that the first day of law school. It depends. And the answer is it depends upon, and I'll give you a specific answer and an example on how you determine whether or not that is compensable time. One, it depends on what you want to do. You're saying to the employee, look, I want you to be available, but because I'm telling you to be available, I'm going to give you X amount of dollars. Just there you go. As for any potential inconvenience it might be, or just simply being available. Do you have to? You don't have to. But if you want to encourage the employee to do that, perhaps that's something you do. On call really is meaning that I'm telling you, you can't travel a certain distance. You can't be unavailable to me. And within a short time, you have to either come to me or report to work or call in. If that's the case, and then the person actually does call in, once they do call in, once they do show up, it's compensable time. But if they cannot attend to other personal activities, can't go to the movies, can't be sound asleep, can't travel to Bora Bora, whatever the issue is, then it may be compensable time. But if they can go to the dry cleaners, go to a restaurant, go to a movie, and just simply respond within a reasonable period of time, it's not necessarily compensable time. That's on call. With regard to the safety plan, the question is, I thought this was only filed one time. And yeah, you submit the safety plan. It used to be submitted every 2 years, but what you do is you submit the updates to that. If you have any changes to your from your safety committee, a known hazard that you've now corrected, you would update your safety plan, or you've changed it somehow. And where employers were changing it was during COVID, they were changing their screening protocols and the like. Why doesn't the state allow federal rules and how kids, why doesn't the state follow federal rules with how late kids can work? State is okay with 7 p.m. The federal is 9 p.m. Inspectors always play it safe and stick with 7. So I stumbled over that, but I'm also smiling because the differences between the federal and the state. What governs? What governs typically is the more protective statute, the one that provides the greater protection for the youth. And again, the U.S. Department of Labor, the New Hampshire Department of Labor, while they adopt certain things from federal wage laws, overtime exemptions, the definition of compensable time, and so on, they also have their own rules. And the New Hampshire legislature adopted more protective laws with regard to youth workers than the feds allow. So therefore, what it is you align with what the state says because you're in New Hampshire. Yeah, to be honest with you, I'm not sure of the times. I do know that there are specific times based upon the employees, the age of the employees. So whatever it is with the state, you could look at that. But I think if the state is more lenient in this regard, and the feds are more strict, understand the feds are out there too. Even though yesterday in Congress, the new Republican majority in the House filed a legislation to cut back on the number of IRS agents. They didn't do the same with regard to U.S. Department of Labor, and as a part of the infrastructure bill, the Department of Labor has been authorized to hire 100 new inspectors, wage and hour inspectors. So what I would say is be careful in that regard. I would go to, as you said earlier, go to the more protective, which would be 7 o'clock to limit the hours between the feds and the state. Go to the more protective. And again, because if you have a U.S. Department of Labor inspection come in, they're going to go to what their standards are. If you have a state Department of Labor inspector come in, they're going to go to their standards. And you can say, "Oh, I complied with the feds." Doesn't matter. I complied with the state. Doesn't matter. I have an employee who comes in early and sits in the parking lot. He's not clocked in. He's not working. What is the liability of the property? Well, once on your premises, it's really no different than a guest coming to to your property. If you have a known hazard or something like that. But if they're not working and they're just sitting in their car smoking cigarettes, checking their TikTok, whatever it is, you don't have to pay them. I had a case. I was laughing because I had a case where an employee lost her license because of a DUI, and a friend would drop her off at work 2 hours before her scheduled shift, and so she would sit at work and basically, play block games on a computer, send emails to friends, get a cup of coffee, and so on. Is that compensable time? Absolutely not. It's only compensable when they actually commence work for the benefit of the employer. But be careful in that regard. Now, there is a rounding rule, and the rounding rule is employers can round to the nearest quarter hour for purposes of determining whether or not what the actual start time is and end time. However, the Department of Labor takes a position. If you round, and it's called the nearest quarter hour, I refer to it as the 7-minute rule. You can round up or round down by 7 minutes, nearest quarter hour. The Department of Labor, however, takes the position that if you round up to the benefit of the employer, you have to round down or up for the benefit of the employee at the end of the day, which is absolutely makes no sense at all. So just keep as accurate a time record as you can for those hourly and salaried, not exempt from overtime employees. If an employee gets to work an hour early, gets dressed, and starts putting their station together without clocking in, and a manager catches them, are they allowed to tell them to stop and wait till the scheduled time? Sure. But that period of time that they came in and started setting up, that is compensable time, and they should be paid for that. Again, that's sort of, you got to manage delicately in that regard, because you want to make certain that, that was a motivated employee that came in to get stuff together for your benefit. So you want to be careful about disciplining that person, but you would have to compensate that person for that particular day, for that time. So we'll close out of questions now. Let's see. And on to the next. Number 5, failure to pay the 2-hour minimum an employee's regular rate on a given day, which the employee reports to work at the request of the employer and work is not available. This does come up in hospitality, and it comes up in restaurants all the time. And it was especially an issue during COVID. I'm talking about not when you were not open for business, but why? Well, you could have been open for takeout, let's say. But this is a situation where the employer requests the employee, schedule or otherwise, to come to work. The employee leaves home, comes to work. The employer says, no work for you today, whether it's a low census or we had a water break, we have no electrical power, whatever the issue is. And so in that case, the employer must, because the employee had an expectation of working certainly more than 2 hours, and you said you have an option. Either pay them for those 2 hours and send them home, or put them to work and pay them at their regular rate for at least 2 hours. And do they have to do their regular job? No, you can have them do something else, but you pay them at their regular rate for those hours worked that day. The exceptions would be a couple of them. One is if the person is regularly scheduled to work less than 2 hours, and they know that when they're hired, say their job is to come in and check the boiler in a hotel or in a restaurant for that matter, or to make sure that everything is up and running. If it's less than 2 hours, you only have to, and they come in, you pay them just that amount. Where it's come up before is like you have, I want to have a staff meeting. And the staff come from home to the office, not scheduled to be there yet. They come from home to be there with other people scheduled to be there. You would have to pay that person who came from home for that purpose, even though the staff meeting is supposed to be a half an hour. The Department of Labor takes the position that, but that's not their job. Their job they figure they're going to work at least 4, 6, 8, 10 hours, and you have them come in for a short break, short meeting. You've got to pay them 2 hours. So be careful about that, meaning schedule your work meetings during the person's regular shift or at the beginning or end of their regular shift. The other one that comes up is, say the employee comes in and there's a low census and says, look, I'm a tipped employee, I don't want to be here. You still have to pay that person their hourly rate for 2 hours. However, if the person says, my kid's sick, I want to go home. If it's a family emergency or their own illness, you don't have to pay them, and you pay them for just the time that they were there. You don't have to pay them a minimum of 2. So that one has come up a lot, and it was a COVID issue. And there was actually a case we had in this last year where the Department of Labor said someone attending online training where they were home should be paid a minimum of 2. We convinced them that was not what the statute said. The statute was really just understanding where the employer says, come into work, the person makes the trip in, and they're told, sorry, no work for you. That's really the standard. Number 4 is undocumented workers. Well, that's a hot topic in the news these days, right? And the issue there is the I-9s. You're all familiar with the I-9 form. The I-9 form talks about you must verify at the time of hire someone's identity and authorization to work in the United States. And if you've seen the form, hopefully you have, and the form's evolved over the years, but it's called the ABC. One from column A, it's like a restaurant, or one from column B and one from column C. One from column A, which would satisfy the identity and authorization to work, or identity in B, authorization to work in C. So you have those options. Can you dictate what document you get from A or B and C? No, the employee gets to pick which one they can present. It must be genuine on its face. They must present an original, and you can keep a copy of it. You should keep a copy of it, even though the law doesn't say that. You want to prove that you filled out section 3 of the I-9 form that says, I looked at the document and it appeared genuine on its face. So that's not questioned. Keep a copy of it, and you keep it attached to it in the personnel file. So this is an odd one because they say, well, isn't that really more of a federal issue under USCIS or ICE? It is, but we also have what's called the Citizens Job Protection Act, which is RSA 275A. And that one says that you can't hire someone who's not legally allowed to be in the United States. So what proof do you have? You have proof of the I-9 form. We found that employers during COVID, again, tried to keep the lights on, tried to keep the services going, and were a little sloppy with their I-9 forms. I just had a big case with the Department of Labor here in New Hampshire where they hit the employer with not having those forms. Now, the employer actually had the forms, but they were kept separately in the cloud because they were a large multi-state employer. And we got the department to back off those violations. But should they be kept on site if at all possible? But they're kept in a discrete location where you don't have nosy employees going through personnel files and saying, see, I told you so-and-so's accent, they're from this country or that country. But it must be completed, and you must have it. The standard says within 3 days of the date of hire. My view is at the time of hire. Don't let them commence work without the I-9, because if it's 3 days, then it becomes 5 days and becomes 3 weeks. And it's like, oh, I never really got that. Don't do that. And then really the 3-day rule is only if the person says, during Hurricane Katrina, it wiped out my birth records, or, they're kept in Buffalo and they're under 8 feet of snow at this point. That's really what we're talking about, is the delay because of needing to get duplicate records. That's the I-9. Number 3 is, I refer to this as the Reidy kids rule. I would say to my kids when they get hired for jobs in high school, so what are you making? And I think of my son who got a great internship at his freshman year in college, which was working what was called Christian surfers down south. He was teaching surfing and doing irrigation systems during the day, and making money in that regard. But he called it an internship. And I said, great. Are you going to be paid? He said, not initially. In other words, no. But my other kids, when they got jobs, I said, so what are you making per hour? And they said, I don't know. That is a problem. The Department of Labor says, yeah, we've got some employers taking advantage of employees. Now, I have a hard time believing that, especially in this economy, when employees are basically going to the highest bidder. Really, you're paying me $10 an hour. Well, Amado's is going to pay me 15 and give me benefits, and so on and so on and so on. So this is one that you must have at the time of hire, a written notification of the employee's wage rate, meaning if it's an hourly rate or salary, pay date, the day that which they'll get paid, the pay period, weekly or biweekly, and a general description of the fringe benefits available to them. You don't have to list all the things, just simply saying, as a full-time employee, you're eligible for our group health insurance, life insurance, and so on. See human resources for more details, or you get X number of days of vacation or PTO, whatever it is. That's all you need. Or you're eligible for PTO, see HR for more information. That's adequate. But the employee must sign acknowledging receipt of that, and you take a copy of that and you put it in their file. I've had a big case recently with the Department of Labor where, again, it was a COVID issue where people were hired and we didn't have those documents in the file, and we had to replace those with other documents. And what was problematic was we had to find some former employees and provide them with the same notice. I know you're not working here anymore, but here's a copy of what you did make when you were working here. So to avoid that, it is a written notification at the time of hire of their pay rate, their pay date, the pay period, and a general description of fringe benefits. And a copy of it is kept in the file with an employee having signed an acknowledgement of that. And you have to keep that. You also have to keep a written notification in advance of any change to those things, change the pay rate, the pay period, the pay date, and the fringe benefits. For the fringe benefits, how involved does it have to be? Not very. Again, you can just simply say, we've gone from Harvard Pilgrim to United Healthcare, and see HR for more information. But it must be a written notification in advance of any changes. So if you give someone a pay raise, you have to give them a written notification of, as of this date, you will now receive X amount in your hourly rate or your salary. And the employee acknowledges receipt of that, plunk in the personnel filing. And that's one that they find all the time in violations, and it is so simple to avoid. That should definitely be a part of your onboarding process. Failure to keep accurate records of all hours worked, not recording short breaks. So I mentioned that earlier. I think it was item 6 or 7. This is where they actually focus on the short breaks, not recording meal breaks taken or breaks less than 20 minutes. So we're focusing really on breaks, and specifically meal breaks. Under our statute, that the employer must give an employee a 30-minute, must permit an employee to take a 30-minute unpaid meal break after 5 consecutive hours of work in a workday. And you record that meal break taken. Now, can you have an automated system that deducts after 5 hours, I'm deducting 30 minutes? Do not do that, because that is not an accurate record of all hours worked, because it doesn't show exactly when the person stopped working and started to enjoy their meal break time. Does the employer have to, can you allow someone to eat at their workstation? Yes, you can. But if their work break is not at least 20 minutes of uninterrupted time where they're not working at all, then you have to pay the entire time. So I allowed you to take a meal break. I allowed you to do it at your workstation, and I'm telling you, don't work during this time. You can clock out at the beginning of the meal break and the end of the meal break, and doesn't matter if they're munching and so on. But if the person doesn't get a break of at least 20 minutes, that's the short break standard. If a break is not at least 20 minutes in duration, it's considered to be continuous time worked. So be careful in that regard. Make sure that you're truly relieving the person of time worked. What about shorter breaks? Meaning they took 10 minutes here, they took 10 minutes there, they took 18 minutes here. That surely satisfies the 30 minutes, right? That surely satisfies the 20-minute break. Nope. You cannot cobble together the shorter breaks. Anything shorter than 20 minutes in duration is considered to be compensable time and hours worked. Can a person do a meal waiver? So where does that typically come up? I have a 6-hour shift. I'm not taking a half an hour after 5 to take a break that's unpaid. Or I'm working a 10-hour shift. I'll take a break after the first 5 hours. Does it have to be precisely 5? No, it can be sometimes between the 5th and 6th hour. And do I have to sit around at the end of my 10th hour and have another meal break? No. You can have a meal waiver in place. The person can clock out at that point. So I would view with regard to a 10-hour shift, which you rarely have, but if you had a 10-hour shift, I would say the work stops at 10 anyway. If it was a 12-hour shift, you probably want to have 2 designated meal breaks within that period of time. But oftentimes employees say, okay, I'm here for 12 hours, but effectively I'm here for 13 hours because, and one of those hours is not paid because it's a meal break. Can the person waive one or both of those? They can. There is a meal waiver you can have that was on the Department of Labor website, and the person can sign off on it. The danger with the waiver, however, is the person says, I'm waiving my meal break. And that's great. But what if the person then takes a break? You have to remind them you can undo that waiver on any particular day. You just have to show on your time, meal break taken. Does the Department of Labor really care about someone's nutrition and getting a break? Not really. It's just the statute says you must permit someone to take a break. What about bathroom breaks or smoke breaks? Well, bathroom breaks, again, hopefully it's not going to be more than 20 minutes. The person might need medical care. But the issue with that is bathroom breaks, you should permit those. Hydration breaks, look, I got to get a glass of water or something like that, or I got to walk around for a minute. Again, any break less than 20 minutes in duration is considered to be regular hours worked. What about a smoke break? There is no entitlement under state law for someone to get a smoke break. Even if they say, I've got a disability because I'm addicted to tobacco or to vaping and the like. No, you don't get a work break for that. Can you allow it? Yes. But remember, if that smoke break is less than 20 minutes in duration, it's considered to be compensable time, and you're paying for that person to go have a smoke. But you can also, under the Indoor Smoking Act, which is RSA 155, you can actually ban smoking on your campus within a reasonable distance. So again, entirely up to you what you'll permit in your workplace. And remember, just with regard to breaks, the Department of Labor will look at your records and they'll go back 18 to 24 months. And your day-to-day recollection is not going to be particularly strong. So just make sure you've got good records. And again, avoid automatic meal deductions. The Department of Labor does not like those because they are not an accurate record of all hours worked. That's an automated record, and you shouldn't have that. And the number one worst wage and hour violation, the most common one from 2022, failure to report or obtain a workers' compensation policy. This one, I will tell you, was a shocker to me because we typically don't see this one. If you've got one or more employees in New Hampshire, you have to have workers' compensation coverage. That's under our statute. And if you don't, you could be facing unpaid wages, but more importantly, very expensive medical bills, because workers' comp's not going to cover it unless you listed that, unless you had the coverage. So be careful in that regard. And your health insurance, they say, see, insurance companies like to fight with one another, and they say, wait a minute, why am I paying for this under your health insurance? That's a work-related accident. That should have been paid by then. So you might have your health insurance period not pay for a work-related accident or illness or injury. So if you've got one or more employees, make sure, one, that you've got coverage, two, that the employees are listed, and three, that you don't let coverage lapse. Now, I'm going to go back to questions here in a second, but before I do, I've got a final word with regard to tip pooling and tip sharing. I've got several active cases going on right now. We did a program, Jen Meckel, my partner, and I did a program, I think back in November, on tip pooling and tip sharing under our state statute. Our state department, well, under federal rules, of course, in 2021, there was a new standard with regard to the tip credit. For your tipped employees, can you have a tip pooling or tip sharing system? What does that mean? Tip pooling, similarly situated employees pooling their tips together and sharing them? Sure. Tip sharing, That's tipped employees sharing with non-tipped employees. Can that be done? Yes. But the Department of Labor takes a very strict position. They say it must be truly voluntary, meaning the employer cannot impose this system on the employees and require that they tip pool or tip share. And it can't be coerced either. Do it or else. Here's the part that really gets us, and we have an ongoing case and effectively a dispute with our friends at the Department of Labor on this. The statute says that it must always be at the request of the employee. Does that mean that the tipped employee shows up on their first day of work and says, oh, and by the way, I'd like to establish a system for tip pooling or tip sharing? And the employer says, oh, that's a very novel concept. We should consider that. It doesn't make any sense. You can have a system in place. It can't be coerced. It must be voluntary, which means the tip employee must have the option of keeping his or her tips or tip pooling or tip sharing. And they must be able to opt in or opt out daily, meaning, you know what, it was a low census, or I didn't really get a lot of help. I had to bust my own tables and expedite my own food or whatever. I don't feel like sharing, or so-and-so's a jerk. I'm not going to help them out. Or I really would like to tip more today. They decide how much and to whom. They, meaning the tipped employees. Managers cannot participate. That was an issue with the Department of Labor in the last year, and it can be administered by the employer. But the best system is that it's truly voluntary, that there's a policy in place. You document not only the potential for opt-in and opt-out, but you also document, certainly under federal and state laws, your compliance with the tip credit. Meaning if the tips fall below minimum wage, you supplement. And you make sure that the employee is paid at least minimum wage. I'm going to go to questions here, back to Q&A again. If an employee is on call, we're back to on call again, and it is considered compensable time. Are they expected to be paid their hourly rate, or does it have to be a regular rate if they're actually called in for work? Very good question. The answer is you can have a separate on-call rate, which is I'm going to pay you $10 an hour for being on call, or I'll pay you a flat fee for simply being on call. I'm going to pay you $25 to just be available. But when you're called in and actually perform the work, I'll pay you your hourly rate. You can certainly do whatever you want. It's entirely up to you, but you don't have to pay the regular hourly rate just simply for being on call, unless they're restricted in how far they can be, and they have to be basically sitting by a computer or sitting by the phone, or within a short drive back to the place. At that point, it might consider to be compensable. But if they can go to the dry cleaners, they can go to the movies, they can eat, they can hang out with their kids or whatever, and they have to respond within a reasonable period of time, and it might be a call or an email or a text, or they show up, then they're back on the clock, whenever that is. We don't require our staff to clock out for lunch or dinner. They are paid from the time they clock in until the time they leave. Does that have to be recorded? I think that you just have to have a record that, because the Department of Labor says you can pay for a meal break if you want to. You just have to have some acknowledgement that the employee knew that they could take a meal break. So I would prefer that your time records show that that the meal break taken, basically, it's paid, but it shows that the person had a meal break. So you don't have that disgruntled employee a year and a half later saying, "Oh, I never got my meal time." So I would just put down a meal break taken, and then, but you're paying them. At a restaurant, if employees have their meal break while working and are paid during the meal break because they're working as well, is that in compliance, or am I obligated to have them go on an unpaid break? No, I think I just answered that. So the answer is, if they're eating while working and they're not taking a break greater than 20 minutes in duration, just indicate meal break or allowed a break, but they were paid for that time. Where can I find a policy for tip sharing so I can review it after the meeting? Yeah, contact me, send me an email, and my contact information is at the end. Tip sharing, again, is with non-tipped employees, and it should be voluntary. And the employee should know, tipped employees should know that they have the opportunity to opt in and opt out on a daily basis. So I'm happy to provide that to you. Do salaried managers need to clock in and out? That's a good question. also do salaried managers need to work 40 hours in a week? I'll do the reverse. Is full-time 40 hours? Depends on what you determine 40 hours to be. It could be 30, it could be 35, it could be 37, it could be 45, it could be 40, whatever you determine your full-time work is. Salaried is a predetermined amount, actually a fixed amount for a predetermined period of time, a fixed amount for a predetermined period of time to be paid to the employee without regard to the quality or quantity of work. So a salary is RSA 275 43B, and it is one where you pay that fixed amount for that period of time. Now, do they need to clock in and clock out? That's an interesting question. That's what I referred to at the very beginning. The answer is it depends on whether or not that person is considered to be overtime exempt. If they're not overtime exempt, they should clock in and clock out, because if they exceed overtime, if they exceed 40 hours in a work week, they might be eligible for overtime. My view, however, is that if they're a manager, they're not performing the work itself, meaning they're not doing manual labor, and they fit either under the executive or administrative categories for overtime exemption. As long as they're paid at least $684 a week, $684 a week is the salary threshold, and they fit into the categories of executive, non-manual work, overseeing at least 2 employees, or administrative, performing work that is non-manual and free from independent. They've got independent discretion and control over matters of significance. They're true managers and supervisors. No one's looking over their shoulder. They're doing their job. They probably don't need to clock in and clock out, but you have to fit within the overtime exemptions. We'll probably do a separate program at some point with New Hampshire Lodging and Restaurant on overtime exemptions. So I hope that was helpful. I hope that time spent today, that the hour or so that we spent doing that, was good and to your benefit. I think I've answered a lot of your questions. You've been through a lot in the last 2 years, and so this is for you, my thundering applause. Well done. Appreciate you guys. And I think brighter days are ahead. So, but let's be careful out there, because the Department of Labor is sending its inspectors out. Look over this top 10 list. If you have any questions about how to do an inspection, you can always contact me, and my contact information is there. Send me an email, and I'm happy to send you my checklist on inspections. And I think that question earlier with regard to tip sharing policy, I'm happy to send a sample in that regard as well. How was that, Amy?
That's great. So I think just another question just popped up to clarify that your last answer about a salaried employee.
Okay, so I'm a bit confused. If there's an additional payment due to a salaried employee who works more than we ask them to, in other words, if the company asks for a 50-hour week for salaried employees, does that mean they get extra pay? And the answer is it depends. If that salaried employee is overtime exempt, you don't have to pay them overtime if you just pay them their salary for the 50 plus hours. If the person is not, doesn't fit within the overtime exemptions, then anytime over 40 hours in a work week, you might have to pay them overtime at time and a half for those extra 10 plus hours. The answer to that is going to depend upon, again, the circumstances of that salary, 684 plus fitting into one of the exception categories under the Fair Labor Standards Act.
Okay. There's a lot of ambiguity in a lot of these answers. So does anybody have any additional questions before we let Jim go? We do have his email. I will be sending out the recording and the slides to everyone after the fact. So you will have his contact information that way as well. He will be back. We have 2 scheduled Workforce Series webinars with Jim. On March 28th, we'll host update on evolving discrimination laws. And on April 18th, we're hosting a compliance guide to federal and state youth employment laws. So keep your eyes open for those Zoom links if you want to join us on those topics. And it doesn't look like any other questions have popped up. So thank you so much, Jim, for taking your time. And I promise next time I'll make sure everyone can see your active face.
All right, I'll make sure I wash my face and brush my teeth. Thanks so much, guys.
Thanks, everyone.
Bye-bye.
Have a great day.